say, we need to do due diligence, I was like, I have no idea what that is. And for years, the idea of due diligence mystified me. You know, due diligence, it was scary sounding. I mean, you know, it sounds like it was a mystified concept. And over the years, you get to be more comfortable with it. And it's really not as, in a way it's bad that I've started by giving you that big list, because a young associate is like, okay, due diligence, what is that? Give me a and they'll say, you have to get a due diligence request list. And you get a due diligence request list, which is this 10-page document that asks all of these tortured and redundant questions. And it's like, why am I asking these questions? Why am I doing this? I mean, how do we determine, you know, it just doesn't make any sense. So you have to step back and ask yourself, why are we doing this? What drives due diligence usually, and if you kind of go back and look at that definition, is, I mean, due diligence comes up in the context of transactions generally, and we'll talk about what types of transactions: real estate acquisitions, corporate acquisitions, offerings of securities, okay? But the two kind of key questions and fundamental questions are, and let's assume we're representing the acquirer, okay? Well, when we're talking about corporations or real estate, let's assume we're representing the acquirer, the buyer. If we're talking about securities offerings, capital markets, let's assume we're representing the issuer, Bank of Georgia. Georgia's most active issuer of securities on the international markets, who is a client of our firm, okay? Issuer of securities. The first question when you're thinking about due diligence is, what is my client's appetite for risk? What is their appetite for risk? How much risk are they willing to take? You have clients who are completely risk averse and they want you to dig into everything. You have clients who don't care much about risk, and we'll talk about why they don't care much about risks, and who think that you as a lawyer are completely annoying to their business deal by talking about due diligence and all the things they need to check into. They're like, oh, you're a typical lawyer, just trying to drive up your fees. I don't care about the risk. I want to buy this company. I know what's involved. Get out of here. Okay, so between those two extremes, you know, what is their appetite for risk? Are they cautious or are they cowboys? Secondly, and this goes to something that the Black's Dictionary brings up, which I think is a very important piece of it, what are the legal requirements? What are the legal requirements or obligations that the client might have that drive the depth and the extent of due diligence? Who does this client answer to? Okay, who does this client answer to? You might be dealing with a manager, you might be dealing with a shareholder of the client, but what kinds of legal requirements and obligations does he have as an individual, or do they have as a corporation or as a bank, that determine the extent and the depth of the due diligence that you're going to do? And you will find, as you go through your career, that those tend to be the two kind of key issues. How much risk are they willing to take, and what is the context that they're working in? Okay, what kind of legal requirements or obligations are determining the depth of information that they need to get for this acquisition? So the kinds of issues that go into this, or go into answering those questions, are, first of all, what kind of client is it? What kind of client is it that you're representing? Again, let's think about representing an acquirer or an issuer in a securities deal. Is the client public or private? When I say public, I mean, do they have, you know, is it public and listed on a stock exchange? It can be the Georgia Stock Exchange, it can be the London Stock Exchange, it can be the AIM exchange in the UK. So if they're public, they have lots of public shareholders, and they are highly regulated about the riskiness of their actions. Otherwise, the management of that company, will be sued by the shareholders, who are, you know, moms and pops, as we say. The shareholders are average citizens, and they need to be protected from stupid decisions and risky decisions. So if the company is public and its shareholders are moms and pops, or even worse, the pension funds of moms and pops, institutional shareholders, then they are going to be very risk averse. They are going to want a very intense due diligence. If, on the other hand, it's a private company, a closely held company, owned by a small number of partners, and there are some very big companies in the world, that are privately held, that are owned by families. For example, Maersk Mahler, which AP Mahler Terminals, which bought Poti Port here in Georgia, Maersk Mahler has gone back and forth between being public and private, but one of the biggest family-owned companies in the world, a huge corporation, but owned by a family. And to a large extent, they can make a free decision without thinking about shareholders and pension funds about how much risk they want to take. So, duty to shareholders. Duty to lenders is, does this client have a lot of lenders, and in particular international financial institutions like IFC and EBRD, public lenders, that they're going to have to answer to. Lenders are like stockholders in the sense that these are other parties in the company besides the management that the management needs to think about. And lastly, duty to regulators. Is your client, is the acquirer in some industry that is answerable to regulators? So for example, banks. If you're representing a bank in an acquisition, they operate in a highly regulated environment. There's only certain kinds of risk that they can take on. Or again, in the public offering of securities where you represent an issuer, that's an entirely regulated environment where the degree of due diligence that you do is determined by regulations, and we'll talk about that a bit more. Second sort of consideration is what kind of transaction is it? And this is the part that I probably want to focus on the most after talking about these general considerations. Is it an acquisition of real estate? And all of these types of transaction will require a different due diligence, a different level of due diligence and a different type of due diligence. Is it an acquisition of real estate? Are they buying a piece of property? There's a difference between whether they're buying a piece of naked property, undeveloped property, or a piece of property that's already in development, because there's going to be a lot more to know if it's already in development. I hope this isn't too obvious for you guys, by the way. Secondly, is it an acquisition of a company? Okay, acquisition of a company, especially if it's a majority stake, tends to be the most comprehensive kind of due diligence and the most complete. We'll talk about it. Third, is it a loan financing? Okay, that's entirely different. Are you representing a bank in loaning money to, let's say, a Georgian borrower? Let's say I'm representing IFC or EBRD, or back in the good old days, 2007, JP Morgan or Merrill Lynch, in, you don't see them around here these days, unfortunately, loaning money to a Georgian company. If it's a loan, and that's a different kind of due diligence. And you can break that down into several different types of transactions that require different types of due diligence. Is it a corporate finance, a loan to a company for its operations? Is it a project finance, where the project is the security and the revenue for the loan? Is it a secured loan or an unsecured loan? Are they taking collateral to secure the loan, or are they not taking collateral to secure the loan? Or is it that creme de la creme, the guaranteed loan, the parent guaranteed loan, or state guaranteed loan, where the lender has practically no risk, and that's where they tell you that they don't really care about due diligence very much because they're pretty much guaranteed of getting repaid. Or is it, lastly, a public offering of securities, which again is quite a different, very different framework than the other stuff that we're talking about, although in substance it's basically a lot like a corporate M&A due diligence, what you have to do. A third factor is what's the timeline? You know, how much time do they have for the transaction? I mean, we all have the experience that clients come in and they say, and especially this was typical when things were very hot, you know, they want to acquire a big company and they want to do it in 2 weeks. And you as a lawyer are like, oh my God, I'm going to kill myself, because it's just not nearly enough time. And people come in, clients will come in with really extreme demands about timing. And if they compress the time frame like that, then it's going to definitely affect the kind of due diligence you can do. I would say that most reasonably smart, reasonably risk-conscious clients are going to give you 6 weeks to do the due diligence on a significant corporate acquisition. I mean, that's about what you need to get the process ginned up, the data room that has to be set up, to do the work in the data room, to write the due diligence report, you know. But how much time they have is going to be a big factor. If they come in and they say, we got to do this deal in 1 week or 2 weeks, then basically the conversation you're having with them is, okay, you know that we cannot do a proper due diligence in that amount of time. So we have to talk about how you're going to mitigate the risks that you're taking on by not doing the due diligence, and we'll get into that. So timing is a very big factor in whether how much time they give you is a factor in how much due diligence you can do. usually how much time they give you is also a factor of how much due diligence they want. If they give you a short amount of time, they actually don't want a lot of due diligence. If they give you longer time, they do want it. That due diligence list I've given you, you'll notice that at the beginning it says acquisition of 96% of the shares of target company. This was a Georgian M&A transaction in 2006. One of the few really big private sector M&A transactions in Georgia. And you know, we had a good 6 weeks, 2 months to do that due diligence. It was quite a high dollar acquisition, tens of millions. A private equity fund that had institutional investors and therefore had to be very risk conscious, complicated Georgian enterprise. You know, so, and that due diligence risk reflects it, the fact that we were going to get into everything. We were going to go into all the corners. But even big companies, and even big companies that have institutional investors, will do a due diligence on a short timeline if there's a driver. And I forget what the transaction was, but there was a famous transaction 2 or 3 years ago of a couple of big Fortune 500 companies in the United States that did this massively accelerated merger. It was in the tech, Hewlett Packard, and it was one of these big tech mergers. And they mitigated the risk, and we'll talk about the acquirer mitigated the risks of the acquisition through various mechanisms that we'll talk about. So timing is a big factor. And then now mitigation of risk. And basically I call this mitigation of risk versus due diligence, because essentially there's a relationship between these two things. The more due diligence the buyer does, the less the seller is going to be willing to mitigate the buyer's risk in the transaction. Okay? And the less due diligence that the buyer does, which is sometimes driven by the seller's schedule. The seller says, you've only got a week to figure out what's going on in my company and buy it, otherwise I'm going to somebody else. If I'm representing a buyer in that situation, and I have been in that situation, then we'll say, okay, fine. You know, all we're going to be able to do is check whether you're registered, and we're going to check whether you've got title to your property, and we're going to check a couple of other key things, because you can't do jack from a dead start in 1 week, okay, on one of these transactions. You can do very little. But what we're going to get is we're going to get all kinds of draconian commitments from this seller to mitigate our risk as the buyer. So what kind of commitments are those? Well, reps and warranties, representations and warranties, where the seller says, I promise you there are no tax claims. I promise you there's no litigation except what's listed on this list. You have what are called disclosure schedule. So, you know, I represent and warrant that I have no tax violations. I represent and warrant that I have paid all my taxes. I rep and warrant that I have no claims against me by the government. All of these very, very, very thorough reps and warranties, which, by the way, you usually get even if you do a lot of due diligence. Okay? So what's the difference? Why is it that even if I do a lot of due diligence, I'm still going to ask for literally about 50 or 60 of these clauses in the contract whereby they promise me that they've never done anything wrong, except in the specifically listed cases attached in the disclosure schedule, versus the situation where I didn't get to do a lot of due diligence? Well, usually what happens is it starts to affect the price. Okay? So one thing is, if I'm going to do less due diligence, I'm going to start using that to drive down the price. And the seller's like, no, 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 the company's worth a lot. And I'm like, well, how do I know? I wasn't able to do due diligence. So then we're going to start talking about indemnity clauses and holdback clauses, which is basically that the seller says, okay, I promise you that if one of my reps and warranties is not true, it turns out that I had a tax liability or something like that, I will automatically pay you without dispute. As soon as you present a piece of paper, I will pay you the amount of that claim. And usually there's a maximum on indemnity. It typically is the price of the transaction. So if I'm buying a company for $100 million, usually the seller's maximum liability for breach of reps and warranties or under indemnity clauses is going to be $100 million. Now, the truth is, as a buyer, you might get into a situation where you have even more liability than that. But the view is, you know, you've got a disastrous situation and you find that the company had $200 million of liability. But the view is that the seller should not have to pay you more than he got from the transaction. So that's kind of the theory behind it. And then you could say, well, okay, that sounds good, an indemnity, he promises to pay me, but what if he's not going to have the money? You know, how do I know that he's going to have the money when I ask him for it? How do I know that he's not going to, you know, run away and go to the Cayman Islands or the Bahamas and live off the $50 million that he got from me and forget about me when I come with an indemnity claim? So the answer on that is we call a holdback. So it's like, okay, instead of, the price is $100 million for your 96% of shares, but instead of giving you the whole $100 million at closing, at the completion of the transaction, I'm only going to give you 60. And I'm going to keep 40 for a period of time. And then you have a big negotiation over how long I get to hold that money back. And then also over what terms I hold it back. There may be they may decide that it should go into an escrow account, for example. So that, because then the seller starts saying, oh, but how do I know that you're going to hand over the money when I want it? You know, there's all of this quibbling that goes on. So for example, there was a major transaction here in the last couple of years. There have only been a couple of large M&A transactions where it's kind of interesting. Despite the fact that there was a very extensive due diligence by the buyer, there were certain problems discovered. So the buyer insisted on indemnities from the seller. So there's some very strong indemnities in the contract from the seller, where the seller says, okay, if this thing goes wrong, and they're specific, if this tax issue goes wrong, or this environmental issue goes wrong, we're going to pay you. And buyer said, yeah, but I don't trust you to pay me. I want to hold back some of the money. I want to hold back $20 million. And seller said, yeah, but I don't trust you to pay it to me when the time is over. So they said, okay, let's put it in an escrow account. So there's an escrow account which has very detailed arrangements over how the buyer can take money out of the escrow account to compensate himself for some liability that occurred, and how the seller is entitled to get the money out of the escrow account in case the transaction, everything goes okay, and he's entitled to get it back. So those are risk mitigators for doing less due diligence. All right, so talk about now the different types of transactions and sort of the kind of due diligence that you do in different transactions. How are we doing on time? I don't actually have something.
It's good. You're about 25 minutes in.
So. Oh, okay, all right. I need to either accelerate or be simpler. Different types of transactions. The mother of due diligence is a corporate M&A transaction, a corporate acquisition. And the first question is, how much of a stake are they buying? If your client, the buyer, is buying a majority stake, they are going to want to do a lot more due diligence than if they're buying a minority stake. Why? Because if they're buying a majority stake, they're taking over the company. They're going to take it over and they're going to run it. They're going to put in the managers. It's going to be on their balance sheet. If that company does badly, it's consolidated with their accounting. It comes off their bottom line, okay? So if your client is buying a majority stake in a company, over 50%, it's going to be a much more extensive due diligence than if they're only buying a minority stake, 25% or 30%. Now a client still is going to ask for an extensive due diligence on a 25 or 30% stake because it might be costing a lot of money. That 25 or 30% stake might be 50 million, 100 million, even more than that. So they want to be sure that the company that they're buying into is going to do well so that they won't lose their investment. The due diligence list that I've given you is a due diligence list for a substantial corporate M&A transaction, about as big a corporate acquisition transaction as you will see in Georgia, which was, well, it was around $50 million. There have been transactions here that are up to $200 million, but $50 million is a big corporate acquisition for Georgia. And you'll see, just to go through them real quickly, I mean, I'm not going to go through everything, but the first part of it you see is, so this is, what is this? This is the list that the lawyers for the acquirer put together and give to the target corporation, for the target corporation to produce documents for the acquirer's lawyer to review, or lawyers to review. And usually they put these documents in a data room. It's called a data room. So the documents are put into a particular room and they're indexed according to this list. And we send a team of lawyers over there to that room. Now people actually do this electronically, so they're called virtual data rooms, and you don't necessarily have to go there physically. It can be on a website. and go there to look at the stuff. So the target corporation, you know, we're acquiring a Georgian company. The target corporation is going to have to take this list, and their legal department is going to be very busy for a couple of weeks putting all this information together and putting it together in an organized way. You'll see that the first part is definitions, you know, because there's a long list of requests here, and people have to understand the language that we're using. So we're talking about affiliated persons. What is the business or the scope of the business when we talk about it? Who is an executive officer? Because there's a lot of questions about compensation arrangements of managers. So we need to define what is a manager and executive officer. Material, another concept that people mystify a lot. Material just means, is it important enough for me to look at? Okay, that's the question. Is it important enough for me to look at? Is it important enough for me to care about? Your client, the acquirer, is going to set this for you. This is the client's call. You say to the client, do you want me looking at every one of these 400 contracts that this guy has? Some of these contracts are for $200. No. Okay? So usually on a big deal, this $50 million deal, I think we set the materiality thresholds at $100,000. Now usually what you want to do, this is an important point, you want to say $100,000 either in one contract or in a series of related agreements, because you don't want to have a situation where you're missing a very important trend or a very important pile of documents because they had a bunch of related contracts that were all under $100,000 and you didn't look at them. Okay? So you want to say, show me all your contracts with a value of over $100,000 either individually or in a series of related transactions. And that does a very good job of kind of pulling in everything that you need to see. So materiality is just the standard of what is relevant, what is important. It's usually a monetary amount. Subsidiary, very important. You know, I want to look at not only this company, I want to look at all of its subsidiaries, anything it owns more than 50%. I have never had a client, even in a big acquisition, who were very risk-averse clients who did any serious due diligence on a subsidiary that the target owned, it's not even a subsidiary, on any company where they had less than a 50% stake. And the reason is it has to do with consolidated accounting, because if it's more than 50%, they're going to consolidate the accounting and it hits their own bottom line. Then you can just see, I'm not going to go through them just because of time, the different topics that we go through, we can talk about them in questions, corporate matters, financings, material agreements, all the different subjects that you're asking the target company to give you documents on. You could actually throw this thing away and tell them, give me everything, okay? But not really, I mean, because again, there's the materiality standards, but you want to look at their litigation documents, their insurance documents, their regulatory documents, kind of all of that. That is typical due diligence list for a corporate acquisition. Why do we, basically why do we do this level of due diligence in a corporate acquisition of a majority stake? Number one, it's going to affect the price. One of the things your client tells you when he sends you out as a lawyer to do due diligence on a target is, I want you to tell me even before you do the report, because they're negotiating the transaction and the price while you're doing the due diligence. I want you to tell me anything that's going to affect the price. Okay, so if they've got a liability that's going to lower the price that my client's willing to pay, then that's one of the things they want to know. You're looking for things in due diligence that will affect the contract terms. What kind of reps and warranties do I want from the seller? What kind of indemnities do I want from the seller? Do I want holdbacks? And actually things can come up in the due diligence that might make your client, the buyer, change his mind. And that happens where they say, oh God, this is a mess and I don't want to buy this company, there's too much litigation, there's too much liabilities, they've got some major problem with the government, forget it, I'm walking away. Now, securities is closest to, a securities offering is closest to an M&A transaction in the depth of the due diligence and the extent of the due diligence, although the meaning of it is a lot different. I'm not an expert on the drivers of due diligence in a securities transaction because we have a lot of experience acting as the Georgian counsel on securities offerings or listings on the London Stock Exchange or other international stock exchanges by Georgian offerers. It's the UK counsel, the English law counsel, that's responsible to advise the client on the British stock exchange rules and the British securities regulatory rules or the American securities regulatory rules that determine how deep the due diligence has to be. What do we have to do on the prospectus? As the Georgian lawyers, we just take instructions, okay? The English counsel or the American counsel or the Polish counsel is going to say, under our regulatory requirements, this is the stuff that as the Georgian counsel you guys are going to have to look at. Most things here have been done in the UK, so we've gotten very familiar with the UK rules. There's also an American element because a lot of these securities are sold in the United States as well, so we have to satisfy the US Securities Exchange Commission rules for unregistered securities. So the lead counsel is going to decide what level of due diligence you have to do. And basically, why are we doing the due diligence in a securities offering? Well, basically, the first reason is that the underwriters, the banks, who are the ones who shop these securities to the market. So when Bank of Georgia, for example, does a listing or an offering of securities on the London Stock Exchange, it hires JP Morgan and UBS, usually, or ING, 2 or 3 international investment banks who are well known to the market, who know how the exchange works, who knows how the market works, who know how to sell this stuff, who know how to comply with the rules, okay? So they're like the selling agents. And the investment banks, or underwriters as we call them in the US, they call them lead managers in the UK, they're the ones out selling Bank of Georgia's stock. And if that stock, if those shares turn out to be bad, if God forbid, or I shouldn't be using Bank of Georgia as an example, I'll get in big trouble. So let's say some other company, okay? You know, if those shares turn out to be bad, if it turns out to be some problem, and the shares drop in value, then mom and pop and the pension funds and all those people that bought the shares are going to be really mad. I bought these shares for $10 and now they're worth 50 cents. You know, you screwed me, JP Morgan, UBS, okay? So in order to protect themselves against liability, JP Morgan and UBS need to do due diligence. They need to investigate very thoroughly Bank of Georgia or any other offer of securities, okay? So they got to do a full-blown investigation, tax, finance, technical, everything, okay? We only deal with the legal part, okay? And all we've been talking about is the legal part, but they often have experts, and they will have financial experts, accounting experts who will look at everything else. Well, what do the underwriters do? They shift the problem to the lawyers, basically. So the underwriter will require, JP Morgan or UBS says to Bank of Georgia, you've got to hire a very good law firm, and usually they'll even tell them which one to hire, or they'll say, here's the 3 that we'll work with. You've got to hire a very good law firm that's going to dig into everything about you and is going to write a due diligence report and is going to write sections of the prospectus, and we'll talk about the prospectus, and find everything, and they have to hire this English counsel, which let's say it's Baker McKenzie or Clifford Chance or one of these firms. They're going to hire Georgian counsel. Because Baker McKenzie or Clifford Chance, who sit in London in their nice English suits, they don't know anything about Georgia, which is where Bank of Georgia works, or Georgian Railroad works, or any of the other issuers of security that we've seen over the last couple of years. So they hire DLA Piper, or they hire BLC as their Georgian counsel, and they tell us what to do. Baker McKenzie or Clifford Chance or whoever it is says, you guys have got to dig into all of this stuff. And it's pretty similar to that corporate due diligence list. You got to pull all of that stuff out. You got to analyze it. Those documents are in Georgian. We don't understand them. They're under Georgian law. We have no idea what they're about. You, as the Georgian lawyer, have to deliver to the English counsel, the lead counsel, the understanding of local law and the understanding of this company that they need for their due diligence, that the English counsel needs for their due diligence. And both of you, the English counsel and you as the Georgian counsel, are going to have to give legal opinions to the underwriters, okay? Legal opinions, big term of art. That means that DLA Piper, Georgia, and the legal opinion that we have to issue as Georgian counsel, or that BLC has to issue as Georgian counsel, is a much tougher legal opinion, actually, than the English counsel issue. It is much more extensive, because we're the ones sitting here with the company. We're the ones sitting here with all of its operations. We're the ones who deal with where all the bodies are buried. All they're dealing with is, the UK Listing Authority and the London Stock Exchange, and a few nice little rules and write little short opinions, and that's it, okay? We're into the down and dirty stuff. And our legal opinions are given to the underwriters, and we say, basically, everything about the company is okay. Everything that is important about this issuer is okay. It is duly registered. It is licensed to do as a bank, or it is licensed as a copper mine, or it has, licensed, it's registered, it owns its assets, it owns its physical properties. It doesn't have any encumbrances on its assets. The transaction documents are legal under Georgian law. And you say, but wait a minute, all these transaction documents are under English law. So who cares if they're okay under Georgian law? Because we're talking about a Georgian company that's the issuer of securities. So, and this is something you deal with a lot in your practice. You've got a Georgian company issuing securities on the London Stock Exchange with UK or English law offering documents. Those documents have to comply with what are called mandatory provisions of Georgian law, okay? So you cannot have something in the listing of Bank of Georgia on the London Stock Exchange that is inconsistent with, for example, the National Bank of Georgia requirements that are imposed on Bank of Georgia. You cannot have it. They will lose their license, okay? Or you cannot have a capital structure in that stock offering in the UK that is inconsistent with the way that shares are registered or transferred in a Georgian company. So these transactions always involve an intermeshing of foreign law and Georgian law, and one of the main reasons they get a legal opinion from Georgian counsel is Georgian counsel is saying, don't worry, all of your English law documents are okay under Georgian law. There's no conflict between them and Georgian law. They're fully enforceable under Georgian law. And I'm in the Free University, so I'll emphasize this, that Georgia has a very liberal legal regime for the use of foreign law. One of the most open regimes you'll find anywhere, in fact, that you can use non-Georgian law for almost any kind of transaction in Georgia except real estate and a couple of other things. Then, yes. Right, so the law firm is essentially taking a lot of the liability, or the underwriter is shifting a lot of liability to the law firm, okay? Very often, one of the first questions that we are asked is, how much malpractice insurance do we have, okay? And because what they are doing, what the underwriters are doing, JP Morgan and UBS, since they don't have any money, right, is they are shifting their risk to the law firm, and the law firm is taking on that risk and issuing a legal opinion. So this is why, if any of you are in the role of clients and you're like, why are these lawyers so difficult and nasty about what, I'm paying them, for God's sakes. I'm paying these guys, and they don't want to say in their legal opinion what I'm paying them to say. Well, the answer is because I've got to worry that I'm going to be sued by a pension fund in the UK if I say something that's not correct, okay? And it's my responsibility in my law firm to protect our very big malpractice policy against claims. And so, that's the way it works. The due diligence, it provides content for the prospectus. Every offering of securities has a prospectus. That's the information circular that goes out to investors. A lot of this stuff that we dig up goes into the prospectus. They ask us to write the Georgian law pieces of the prospectus. Loan financings, just the last two things, loan financings and real estate. When you represent a bank in doing a loan to a Georgian company, let's say I'm representing IFC or EBRD or US OPIC and making a loan to a Georgian company. What kind of due diligence do they want me to do on this borrower? IFC or EBRD, they're about to hand over $40 million to a Georgian company. They want to know that they're going to get it back, right? They want to be sure they're going to get paid back. So they're not going to lend that money blindly. They need due diligence, they need an investigation, they need help to know this company is going to be able to pay the money back. What kind of due diligence you're going to do depends on how they have structured the loan. The biggest due diligence you'll do in a financing is on a project finance, okay? So, for example, hydropower projects. You hear a lot about hydropower projects in Georgia, okay? A hydropower project or an electric power plant is a classic project financing object. You need a lot of money to build it. Okay, so let's take a hydropower plant. You need $100 million to build it. It's going to take 4 or 5 years before it starts generating any money. So I got to borrow $100 million to build it, but then it will generate money. It generates its own revenues. And the way that electric power plants have been built over the last few years is a company or a sponsor sets up a subsidiary. Might be a big international electric power company, or it might be some other kind of company. They set up a special purpose subsidiary. It is the one that buys the land and develops the power plant, and that subsidiary is the one that borrows the money from the bank. And it pledges the whole project to the bank. And the only revenue that is available to pay that loan is the revenue off the project. The 6 tetri per kilowatt hour that goes off that hydro plant. Now, actually, there has not yet been a true project financing of a hydropower plant in Georgia yet. There's been an attempt, and we worked on it, but there has not been one yet. And we could talk about why that is. But because the lender is depending completely on the value of that project, the value of its assets, and in particular its potential revenue stream, it's just like the corporate M&A case. I may be taking this thing over. I depend on its revenue to determine whether I'm going to get repaid. So it's a very extensive due diligence. The second type is kind of the typical secured loan. This is the most common thing that we see here. EBRD loans, $40 million to a steel plant project, for example. They're going to take security in all the assets of that steel plant. So the due diligence that you're going to do is, do they own their land? Do they own the factory, their stuff? And do I have a good security interest, a good mortgage, hypotheca, or giro over their stuff so I can take it if they default? So the main purpose of your due diligence is to find out whether they have good title to their stuff. And then also what you're going to be doing is you're going to be opining that, yeah, the loan agreement, because it's under English law, it's under New York law, is enforceable under Georgian law. Unsecured loans, you don't even see them in Georgia anymore. Back in the good old days, ever, yeah. In 2007, we had them. The international banks had so much money to lend that JP Morgan and Merrill Lynch, as 2 examples I know of, JP Morgan and Merrill Lynch were making unsecured loans, at least to Georgian banks, of big amounts of money, $100 million, $200 million. Georgian banks were good credit risks, and that money has been repaid. But you do not see international commercial banks here now making unsecured loans. You don't have to do much due diligence on an unsecured loan, just basically that the loan documents are enforceable. Lastly, real estate acquisitions, I think it's pretty obvious. The extent of due diligence that you do in any country on real estate depends on how good the land registry system is. Okay? If it's a good land registry system, and one that the legal system gives a lot of weight to, then that's bad for the lawyers because it doesn't require much due diligence. And that's pretty much the situation in Georgia. There is a very good land registration system, the public registry. Not all land is registered, as we well know, but anytime somebody wants to do a sale or purchase transaction or wants to use their property for a mortgage, they go and register it. The public registry is difficult about registering land. They require, in the sense of requiring a lot of documentation. So there's a pretty high degree of confidence that once a piece of property is registered, the person who really owns it is the one who registered it. And a practice has developed here of relying on the public registry extract, the state title document, as very strong evidence that, yep, that's the person who owns it. And the same thing is true for any encumbrances, mortgages, or anything else that's registered on the title. We don't do an extensive title due diligence on real estate transactions unless the client is buying something very expensive. They're spending a lot of money. Usually they're spending a lot of money and it's a piece of property that was privatized. And especially if there's some murky history in the privatization, then it's kind of like, okay, this is too much money and too much of a murky history to just rely on the public registry extract, and we're going to get into the whole chain of title of previous owners and previous buyers and sellers. But it's pretty rare, actually, that we do that these days. And then on a real estate due diligence, the other things you're going to look at are like zoning. How is it zoned, especially if it's in the city of Tbilisi? If it's under development, whether they have construction permits. And usually also things like environmental permits if it's for a development project. That's it.
No, you're fine. Thank you. So what's left to say? Right? I see a lot of young faces in the room, so I guess maybe the job that I could serve here is to kind of pull back a little bit and look at the overview of what the context is here. And this is important for those of you who will be practicing law in the next 2, 3, 4 years, because you'll be thrown in to due diligence and be asked to conduct, to have a major role in this. This will be your responsibility, maybe sole responsibility, when you first start practicing. So you have to have an organized approach to doing the diligence, which is a verb that we've created, doing diligence. So to re-emphasize some of the things that Ted identified is you have different goals. If you're the buyer of an asset versus the seller of the asset. And in the due diligence, as the buyer, you're asking, what do I need to close this transaction? What do I need to know? What do I need to have seen? What documents do I have to have reviewed to get myself, as the lawyer, comfortable with the legal aspects of the transaction? And also on the business side, am I protecting my client's business interests? So that's what you're asking on the buyer side when you're laying out the money. On the seller side, you're asking the opposite side of that. What do I have to provide? And not in the same context that you ask, how do I respond to questions in litigation where it's clearly adversarial? The goals are different. When you're selling a company, one, you need to be responsive to the buyer's questions. You need to tell the buyer everything that the buyer needs to know about the company to get the deal done, to get the buyer to pay you for the company. But on the back end of that is you don't want to create liabilities down the road, further on in time, because of something that you've represented and warranted. One of the worst things that can happen for your client if you represent a seller of a company is for that client to get paid, get $1 million at closing, head off to the Cayman Islands, set up their new life, and then to get a lawsuit 2 years later because they misrepresented that there were no B equity holders in the company, that they misrepresented that they had no product liability issues floating out there. So that's the context. You know, what do I need to close the deal, and what liabilities am I creating by doing the deal? So that drives your organization. When you're a young associate and someone hands you an 80-page acquisition agreement and says, we have to do due diligence here, we have to figure out what, on the seller side, since Ted emphasized the buyer side, I'll talk about the seller side. Often the agreement is done or near done, and they give you the proposed representations and warranties and say, go, fill out the disclosure schedules and tell the buyer everything they need to know. So you start reviewing hundreds of contracts or looking through the authorization filings and so forth, and going through the corporate records and making sure everything is airtight. To get the seller, to get the buyer comfortable with closing, and to get your seller, to the person that you represent, comfortable making the representations and warranties, so that you don't have to call them from the Cayman Islands 2 years later and say, please, a little bit of money to make this issue go away. So, with that in mind, you have to be organized in looking at the transaction. You have to, I usually create charts when you're responsive to these diligence, and I have a PowerPoint, but you get the same idea here. Where you identify the particular schedule, the particular item of the transactional agreement, whether it's item 16C or 32 or whatever, and then you identify the exact language and put it in a chart so that you can see the exact language. And in cut and paste, all this is done electronically now. So just cut and paste the exact representation and warranty language from the document into a chart, and then make comments to the side. I've reviewed this document. I've reviewed similar documents. And then you go through and you have one of these for each different type of contract, each different type of authorization, department records, and so forth. And that's just a practical aspect of being organized and approaching this diligence, to make sure that, one, you cover everything that needs to be covered. You look at all of the issues that have to be covered. And then, two, you don't duplicate your work, right? You don't look at the same contract 8 times. You look at it once and hit all of the representations and warranties that might be applicable to that contract. So that's a practical approach. The other thing to keep in mind is, depending on the timing of the closing of the deal and the signing of the merger or the acquisition document or whatever it is, the diligence may actually drive the structure of the deal, as Ted said. So you might have a holdback provision. You might have a different type of escrow arrangement, so that it might drive how the buyer pays the seller. When is the buyer going to be comfortable relinquishing the cash or the stock or the other assets that the buyer is exchanging for this? And that may change depending on the amount of time and the depth of the diligence that's available. So it's not healthy to just think about the transaction as pro forma, as done in one particular way. You have to be flexible in the way that you structure these transactions, depending about the amount of time that your client gives you to close the deal. And you know, as Ted indicated, that the clients drive the deal, and you can drive your business up. You can become a lawyer who does a lot of these transactions if you are able to respond to these client timelines, to these short timelines, and get a thorough job done in that time. Or if you don't have enough time to do the type of due diligence that you're used to doing, then you are able to protect your client in one way or another through the structure of the transaction. The last thing I guess I should mention, just again to the young folks who are just getting out here soon, need some kind of a context for this, because there's a lot of new language, a lot of heavy concepts, right? A lot of liability, a lot of dollars at risk. The same concepts apply in your everyday purchases. The same concepts that apply to due diligence on both sides apply to purchasing a car. Maybe that's not an everyday purchase, but you would ask the same questions or the same types of questions when you're buying a car that you do when you're buying a company or a piece of real estate. What am I buying? What am I selling? Does it have the original engine? Is the engine sufficient for what the car is supposed to do? Has the car been repainted? Who has title to the car? Those are business issues, right? Those are the business side. What am I buying? Is this a factory? Is this a car? Has this car always been red? Has it been in an accident? Have there been repairs that I can't tell when I look at it? Has it been flooded? And so forth. On the law side, the legal equivalent, the legal issues that you look at is, who owns this? Who has title to it? Can I go back and review the title? Are there problems with registering this car so that I can do what I want to do with the car, so I can drive it? And as the seller, you're the one who's put that car in the buyer's hands. As the buyer, you're the one who has to drive that car, right? You have to take it out, and you have to, your life is at stake. I've ridden around in Tbilisi. I know your life is at risk if the car is not safe, right? So you ask these questions, you know, what's the tire wear, all these things. So you've got business questions, you've got legal questions. Can I get clear title? Can I get this deal done? You know, if I have to have the car today, what am I willing to risk down the road? Can I insure it? Those types of things. So the same exact questions. So this is not, while the amount of pages, while the number of clauses may be daunting, the issue is the same thing that you guys have dealt with in your other, in your former lives, your pre-lawyer lives, right? So I just keep that context in mind, that you can do this. This is not overwhelming. It's something that you can have complete control of, but you have to be careful, and you have to represent your client very carefully and thoroughly in these types of transactions. With that, I think we have a few minutes for questions. Okay, great. So we'll be happy to take your questions.
Offshore in other countries.
Right.
Right, yeah, so the question is, how do you deal with I'm representing a client who's acquiring, let's say, a Georgian, and it doesn't happen very often with Georgian companies, by the way, but let's say I'm representing a client who's acquiring a Georgian company, and the Georgian company has subsidiaries in other jurisdictions or offshore jurisdictions. How do you investigate them? The answer is you've got to get counsel in that other jurisdiction. You've got to engage counsel in the Cayman Islands or in Bahamas or in England, wherever that other company is, and they do a little miniature due diligence on that subsidiary or affiliate. Because I can't deal with the jurisdiction where I'm not located, and I'm not qualified in the law. So I've got to get somebody from that jurisdiction. It comes up a lot when you're practicing as a lawyer in the United States or the UK, big metropolitan centers like that. You've got teams of lawyers. You know, I mean, when I was at Baker Botts, we did a merger, and at that time it was $3 billion, which was, you know, this is 10 years ago. That was a very big deal, and the companies, they had affiliates in lots of countries. We had counsel in lots and lots and lots of different countries who were all feeding in information to the whole process. Anybody else? Don't be shy.
Შემდეგ გამაინტერესებს თქვენი გამოცდილებიდან გასაზრდელით საქართველოს რეალობაში მოინტერესებს. ჩატარებული due diligence-ების შედეგი. პროცენტულად შეგვიძლია შეახსოვოთ დაახლოებით რა წილი რისკების რეალიზაცია ხდება, რა პროცენტი რისკების რეალიზაცია.
So the question is, as I understood it, is what was kind of the ratio between risks identified and risks that were actually realized? Well, the follow-up question was, do you monitor that? I mean, the truth is that clients engage you for the acquisition, and then kind of go on. I mean, and to the extent that risks are realized, they often deal with them on their own, kind of once the company is going. But I can tell you, and I guess this is good, I mean, knock on wood, I have never had the experience that, that after the acquisition, a major risk emerged that we had not identified. And what happens is that when you identify risks during the due diligence, a lot of them actually get solved before the transaction closes, because you know, you identify risks and your client is like, oh, that's bad, that's got to be fixed. I don't want a rep and warranty on that. I don't want an indemnity. I want that fixed. Okay, so a lot of those things get fixed before the closing. The interesting question is about ones where you identify a risk, there's an indemnity for it, Does the risk occur and the indemnity is drawn? I have a situation right now that's bubbling in that direction. Hard to say whether it will come out or not. But yeah, I hope that answers the question.
I'll just add a little bit to that, just on the theme that when things go wrong down the road, people will be sued regardless of how you structure the transaction. So, you know, you can be as meticulous as you want to be in structuring these representations and warranties. My law firm, when I practiced, represented a company selling basically an arts and crafts supply, and that had a large warehouse. And inside of that warehouse was stacks and stacks of construction paper, of thick paper and various colors, red, green, orange, and so forth. And when we sold the company, $1 million, $2 million, small deal, when we sold the company, we made the representation and warranty that the inventory was good and saleable and reasonable and so forth. The buyer took over that company. 2 years later, the buyer wasn't making as much money as the seller was making in the company, obviously sued them. Fortunately, the seller did not feel bad about our representation in the deal and actually hired us to represent them in the subsequent lawsuit. And the question that we were sued over was whether the particular colors of construction paper that were in inventory were in reasonable amounts and reasonably sellable. And we defended it, and we won the lawsuit, but we didn't win attorney's fees. And it's just one of those situations where it was, you know, on paper a good deal. We protected our client, but you still get sued, and it still costs the client money. So there's that may be unique in the American system, but you know, there's only so much risk analysis you can do before when you have the risk of litigation out there.
Somebody else was up there.
ახლა მაგალითების დროს ლაპარაკობთ დიფრენციირებულ კომპანიებზე და კომპანიების გასვისების დროს რისკების შეფასებაზე და ასე შემდეგ. უბრალოდ მაინტერესებს, თქვა იგივე გეგმის შედგენის დროს, როდესაც თქვენ როგორც სპეციალისტი იურისტი ადგენთ გეგმებს ამ გასვისების პროგრამასთან დაკავშირებით, თქვა ეს ლაპარაკი არ არის ავტომობილზე, ლაპარაკი არის თქვა ფაბრიკაზე, ქარხანაზე, ამ ტექნიკური რისკების შეფასებასაც თქვენ იღებთ თქვენ თავზე, ამაზე თქვენ ცალკე არ გისაუბრეთ. ანუ მაშინ უნდა თქვენ სპეციალისტი თქვა ეს ქარხანა თუ ქიმიური ან მიკრობიოლოგია ან ფიზიკოსი და ასე შემდეგ. ეს საკითხი როგორ გვარცხებოთ თქვენ მაგალითად.
Right. I mean, yeah, I think I mentioned that at one point. I mean, you have to. I've been focusing on legal due diligence, but especially in a big transaction, let's say you're acquiring a chemical plant. I mean, the acquirer is going to bring in engineers, chemical engineers, who are going to do an evaluation of the plant. Now, often the acquirer will itself be a chemical company, so it will have the staff. So when you have mergers or acquisitions between companies that are in the same industry, very often your clients' in-house people, engineers, and all kinds of technical experts, human resources experts, insurance experts, all of their in-house people are going to be all over that acquisition. And as the outside lawyers, you're going to be focusing on a fairly narrow, set of things. If the acquirer is, let's say, a private equity fund and is not in any particular business, and they're acquiring a beer company or a chemical company, they're going to engage expert consultants. So technical consultants, accountants, we lawyers are not very good at analyzing masses of numbers. So the accountants, the financial experts, and all kinds of experts are brought in. I mean, there are many aspects of due diligence. Tax. is often really treated as a distinct area of due diligence. In my experience, at least kind of in the American model, most American law firms don't have sufficient depth of tax expertise to really do a tax due diligence. They've got one or two lawyers like real good tax advisors, but to do a tax due diligence, they're often going to bring in an accounting firm.
Interesებს კონკრეტულ შემთხვევაში, როდესაც კომპანია გარკვეული კვლევისათვის პარტნიორს იურიდიულ კომპანიას, რა სახის გარანტია შეიძლება შესთავაზოს იურიდიულ კომპანიამ, ნებრივია ის პასუხისგებს და პასუხისგებელია საკუთარი მიწოდებული ინფორმაციის სწორებზე და იმ შემთხვევაში თუ ამ იურიდიული მომსახურების შედეგად მიწოდებული ინფორმაცია აღმოჩნდება არასწორი ან არასრული და იმ შემთხვევაში თუ ეს გარიგებები საკმაოდ მნიშვნელოვანია და ძალიან დიდ თანხებთანაა დაკავშირებული, როგორ შეიძლება გამოიყენოს გარანტიები, რაც ზიანის მიღების შემთხვევაში იურიდიულ კომპანიამ შეიძლება გაითვალისწინოს და აუნაზღაუროს და ასევე ეს გარანტიები რომ თქვენ ახსენებთ ზეგან ანგარიშზე თანხის გაჩერება, ასე ვთქვათ, დადება უზრუნველყოფის მინიმუმს, მაგრამ თუ ეს ეხება ძალიან დიდ მოცულობით ურთიერთობას, ვთქვათ, რის უზრუნველყოფის საშუალებაც იურიდიულ კომპანიას არ შეუძლია. ასეთ შემთხვევაში როგორ აღიქვამს განვითარებას?
Okay, first of all, when I talk about holdbacks, escrow funds, and all of that, that is for claims as between the parties. Okay, so the buyer finds a big liability in the company, and it was a breach of a rep and warranty by the seller. The buyer is going to make a claim against the seller. Now, the buyer might also say, my lawyer should have discovered this problem, and I'm going to sue my lawyers too. You know, or even it can happen on the seller side. You were talking about seller side due diligence. I suppose it could happen where a client had delegated to a law firm the seller side due diligence and the preparation of disclosure schedules, and the lawyer should have disclosed something and screwed up and didn't disclose something. Okay, so how does a law firm deal with those kinds of massive claims that can be generated? And the answer is professional liability insurance. My law firm has a £350 million liability insurance policy, £350 million per claim. So, you know, we can handle it. Hope it doesn't happen. It's my job to be sure that nobody makes a claim against that policy. That's my job as a partner in DLA Piper. But, you know, we have, and you know, one of the things that you definitely worry about that like might wake you up at night is like, oh my God, they're going to see me as the deep pocket. You know, they're going to decide that like, wait a minute, none of us has any money anymore, but that law firm's got a big insurance policy. You know, let's make a claim against them. So you've got to protect yourself against all of those things. But the law firms make undertakings in 2 or 3 ways to clients about the quality of our work. Number one, we do it by our bar rules. As American lawyers, that's a very extensive set of regulation. I think it's more in development in Georgia, but excuse me, I have a cold. But it's happening here, you know, and under American bar rules, I'm held to a defined standard of professional ability. And there's a whole mass of case law on whether I have met that standard of competence or not. So if a client makes a claim that I was incompetent, I didn't meet a high enough the standard that I was supposed to meet, and that's why they ended up with some big liability. You know, that's essentially regulated by the bar rules and by all the case law under the bar rules about whether I'm going to be liable or not. In the United States, that's the main determinant. The bar rules are the main determinant of a lawyer's liability, which is why, for example, if you ever compare the engagement letter of an American law firm to the engagement letter of a British law firm, the American law firm's engagement letter is much shorter, because there is not much that you can say in the engagement letter of an American law firm that is not already covered by the bar rules, and you better not say anything different in your engagement letter than is in the bar rules. British lawyers are much more free to negotiate their liability with clients, which is an appalling concept to American lawyers. I'm in a British law firm, and we have had a big issue in my law firm with American lawyers like me and a few of us other expats refusing to agree to liability limits with our clients because it violates our bar rules to limit our liability with clients. And DLA Piper has actually kind of come up with a way of coping with that. But outside the United States, English law firms, you will find that they have liability limits in their engagement letters, where they say, we will not have liability beyond £3 million or something, which may be much less than the kind of liability that can come out of the transaction.
Again, just to add to that, the locus or the point of liability for you as an attorney in most of these transactions, the real estate transaction, the M&A deal, the securities offering, is going to be in, at least in the American system, in your opinion letter, in your legal opinion letter, where you put forth your opinion saying that I believe this company is duly formed, validly existing, in good standing in the state or in the country, is authorized to do business, so forth. And that's the result of all of this diligence to some degree. Now, you know, the opinion letters are almost comical in the sense that the first 5 pages are disclaiming any knowledge of anything. You know, assuming no diligence is done, assuming that all, you know, signatures are valid and real, and assuming that, you know, none of these people really exist or so forth. And then, you know, and then you make your 3 opinions. You know, I opine that this transaction looks okay in Arkansas law or New York law, and that, you know, Joe Smith was authorized to sign this document on behalf of the company and so forth. But you're making very, very limited statements on your on that side, on your legal opinion, and then after you make those statements, you know, continue to narrow it down. You will be, you know, held to the lowest liability possible under any case in any state, and so forth. And I'm only exaggerating a little bit. So it's why that opinion letter is so carefully crafted, because it's basically the single point of liability in a lot of ways.
The opinion letter is like the most acute point of liability. It's where you expose yourself the most, because you make, I mean, despite all of those assumption clauses and qualification clauses, we are actually making a few real opinions and a few real statements. And it does happen very often that clients push you and parties push you to make statements that you really do not feel can be made. And you have a very tough process there. But exactly because you really, because I mean, it is police, you know, what they're asking for is an unqualified opinion on 3 or 4 key points. And to give that unqualified opinion on 3 or 4 key points, you're really laying your head on the block, okay? And so that is the most acute point of liability. But I think also a point that I wanted to make, so I was thinking about legal opinions at first, is the truth is that somebody can make a claim against you for the whole scope of representation that you did. You were negligent in the due diligence, you were negligent in failing to include something in the report, you were negligent in failing to warn them about something, you were negligent in how you drafted the contract, and you left out something. So there's many, many ways a client can sue you for negligence. And in America, there's quite an active trade in that. Not so much here, but Georgians are big. And Georgians are litigious, I think. Georgians are also like suing each other. I think it's been that way for a long time. Yeah, I think it's a litigious society. Okay. Any other questions? Okay.
English if everybody seems to understand English. Back to the documents that are issued by the seller to the potential buyer. How does the seller protect itself from the risks like he may pose to deliver that much of sensitive information to the buyer? I mean, the buyers can be potential competitors in the market of the seller.
No, that's a fantastic point, and it goes to the different stages of diligence, right? Due diligence really starts with the first part of the mating dance between the corporations, right? When the two CEOs are talking to each other as to whether they might sell or not, but it continues on. And at the very initial stage, when you'll draft a non-disclosure agreement or a confidentiality agreement that requires the buyer to treat this information as though it were its own information, at least in the U.S. And that's what you start with. And beyond the particular legal maneuvers that you can make and the documents that you can put in place to make sure that the buyer, or that the buyer doesn't mistreat your information or expose you in any way to your competitors, or if the buyer is a competitor, to again use that information to its advantage or disadvantage. Beyond that, you're also talking about disrupting the seller's business, and you don't want your competitors walking down your halls and talking to your employees and getting everyone concerned about transitions, about redundancies, about their job security, about the future of the company, until the deal is very far along. So you do have different stages of the due diligence.
Yeah, a couple of things on that. One, that's a very good point, is that a lot of times these transactions, the seller does not want his employees to know that the company is going to be sold until he's sure the deal is going to happen. So when I mentioned before about a data room, I mean, that's why very often the seller wants the due diligence to be conducted not at its office. They might have it done at law firms. They might put the documents in a third location, in a hotel conference room, so that there, in fact, are not representatives of the buyer crawling all over the seller's facility. The thing you mentioned about competitors is the biggest M&A deal I ever worked on when I was in DC was $3 million. It was actually a merger. It was more of an acquisition of one by the other, but they were calling it a merger. These were the two leading companies in one line of business, a particular type of pharmaceutical business. And they hated each other. I mean, it was like Coke and Pepsi, or Marlboro and Winston. I mean, they hated each other. And they were owned by bigger pharmaceutical companies, and these were divisions that used to be independent. So the bigger pharmaceutical companies, the CEOs were buddies, and they would meet at the club, and they could get along fine. But the people in these subsidiaries that had been competitors for literally like 100 years, when they had been independent businesses, truly hated each other, and their existence was based on competing with each other. And then on top of this, in the United States as well as in the European Union, it brings in a major anti-monopoly factor, which is that you've got two major contenders or competitors in a particular economic sphere who are going to merge, and they're thinking about merging, and you've got enough of a preliminary sense that the merger is going to be approved by the competition authorities. But the competition authorities require that there be all kinds of protection in the due diligence process in case the deal doesn't happen. Because kind of as you said, one company, these are two competitors, the buyer can learn everything about the seller's business and say, oh, sorry, no deal, and then walk away, and they've gotten a bunch of information that they can use to compete. So in the one that we were doing, we had very, very, very elaborate set of rules about who could see what. And for a long time, for quite the first extended period of the transaction, only outside lawyers for the two parties could see things. No staff from the two parties could see things. And then once I think a certain level of antitrust approval had been obtained and there was a certain certainty that the deal was going to go forward, then we were able to bring in the staff. Because the truth was, there were so many technical issues. There was no way that the lawyers, it was pharmaceutical. I mean, all of this science stuff and patent stuff, and you know, it required a lot of experts to deal with it. And we had the most excruciating non-disclosure letter, you know, agreement that you could possibly imagine. And you could tell it was written and negotiated between two parties that hated each other and mistrusted each other. Every possible way they could screw each other was like, you know, addressed in there in detail. I mean, it was a lot of times, you know, we lawyers, you write a document, a confidentiality agreement for one transaction. Of course, you want to use it on the next one. That one is completely useless for anything. I mean, it's, you know, it's like 12 pages long and all full of all these details about different drugs and stuff. You know? But anyway, that's a very, very good point about competition and how competition plays into a merger deal.